This miscellaneous criminal number 5, E558, 2025, Public versus Zakaria. Before this court is an application dated 3rd of June, in which the applicant, the state, seek orders pursuant to Article 49, 1H of the Constitution, and Section 46A of the Criminal Procedure Code to continue detention of the respondent at Nakuru Police Station for a period of 21 days. The custodial order is sought to allow the investigating officer to complete inquiries an alleged offense of murder under Section 203 as read with Section 204 of the Penal Code. The respondent was arrested on the 2nd of June at 1400 hours in connection with the murder of the deceased who worked at an Mpesa shop at Manchi Meat. On the material date, the deceased left deposit Kenya shillings 300,000 at Kenya Commercial Bank and failed to return. A body was subsequently recovered at a location allegedly close to the last known location of the respondent, as indicated by the phone that the applicant advised that the police requires further time to do the following. 1, to record statements from key witnesses, to conduct a DNA from the respondent, and do further forensic testing, and of course to analyze call data and CCTV footage. The further states that the respondent was the last person in contact with the deceased, and that the circumstances warrant thorough investigation before release. The application is opposed by the respondents, who avowed that he has cooperated at all stages, reported the disappearance, and no compelling reasons have been advanced to override the right to bond as per Article 49, sub-Article 1H of the Constitution and Section 36A of the Criminal Procedure Code. So basically, the issues for this court to determine is whether the state has demonstrated the existence of compelling reasons under Article 49, sub-Article 1H of the Constitution and Section 36A of the CPC to justify the continued detention of the respondent. And 2, whether the application for further custodial order should be allowed. So in relation to Article 49, it states, and I quote, an arrested person has the right to be released on bond. Yes, compelling reason not to be released. The other section relied by the state is that Section 36A of the Criminal Procedure Code, which provides, and I quote, a police officer may apply to the court for an order to detain a suspect in custody, and the court may grant such order if it is satisfied that further detention is necessary to complete investigation. End of quote. So look at the bail and bond policy guidelines and what constitutes compelling reasons, including likelihood of interfering with investigation or witnesses, risk of the suspect absconding, a need to protect integrity of evidence, or public safety consideration. We looked at the case of Republic versus Ahmed Abol Fatih Mohammed and another, and also case of Republic versus Danson Mugunya and another, that felt that the burden of proof is always on the prosecution. So in this present case, the respondent is under investigation for more serious offense of murder. The police have provided specific grounds requiring further time for investigation, which are named, which include the need to record additional witness statements, requirement for scientific or DNA forensic analysis, processing and analysis of call data and CCTV footage, which are not immediately available. The respondent was also last in contact with the deceased, and digital location evidence points to proximity with the crime scene. So the risk of interference with the ongoing investigation, especially where DNA has to be taken from the respondent. And of course, the issue of digital and additional witness account remains outstanding. It's real and non-speculative. The fact that the respondent and the deceased were in close relationship, that is husband and wife, as mentioned, by the respondent counsel, intensifies the risks of interference with witnesses known to both. When bond is a right, investigations in complex and serious felonies can constitute a compelling reason for temporary pre-charge detention, as demonstrated in the case of the Republic versus Robert Zikoren Zilani, and the case of the Republic versus David Manyara Njagi. So while the respondent's cooperation is commendable, the need to protect the integrity of the ongoing investigation, especially where specialized scientific evidence being obtained, may in appropriate cases outweigh the right to immediate release. If released, the respondent may knowingly or unknowingly compromise evidence or witness account, particularly where the relationships are close. The court's duty is to balance constitutional rights with the interests of justice. So for reasons set out above, I'm satisfied that the applicant has demonstrated compelling reasons within the scope of Article 49(1)(h) of the Constitution and Section 36A of the CPC to justify the further custodial detention of the respondent. Accordingly, the application dated 3rd of June 2025 is hereby allowed partly in the following terms. The respondent shall be detained at Nakuru Police Station for a period not exceeding 14 days from the date hereof. The investigating officer is directed to ensure all investigations are conducted expeditiously and to respect the respondent's right to humane treatment as enshrined in Article 51, Sub-Article 1 of the Constitution. And lastly, the investigating officer must update the counsel for the respondent the progress of the investigation during the remand period and allow the counsel access to the respondents ordered accordingly. That's
most of the same.
Mr. Orina.
Mr. Orina.
Orina, so
Yes.
was escaping me. What the response? Yes, you want to say something, Mr. Orina?
I want to say something.
Yes.
Your Honor, before the respondent was arrested,
Yes.
he was the one in charge of correcting the funds being used for the funeral, which I am informed by the family will be taking place tomorrow. I was requesting the court whether it could allow the state to allow the respondent to transfer the amounts to the family. And also I would request that the court allows the respondent to attend the funeral tomorrow. To give the befitting send-off as per the culture of the respondents.
Nancy?
I'm informed the phone has been forwarded. The phone has been forwarded for further analysis by the cybercrime analyst. So we will not be in a position to return the same to him as it is an exhibit. On the second issue, your directives are very clear. Releasing the suspect to attend the funeral will compromise the investigations, since there is likelihood that he will interfere with witnesses as he might come across them while in attendance. We are opposed to that application. We pray that the same be declined.
Mr. Wina.
In a rejoinder, Your Honor, we request that if he can be given even restricted attendance at the funeral, it would be.
Restricted, what do you mean now?
He can be given police escort to the funeral to ensure it.
Do you have enough police to do that? Or it's an funeral? Is it practical? Mr. Wina, is it practical?
Your Honor, I think it is practicable by reason that the police officers have the duty to provide that security to ensure that if they are alleging that he can interfere with the witnesses, then they can give him security to ensure that he does not interfere with the witnesses.
The amount received for the funeral, I believe that one cannot happen. We can stored in the phone for forensic evaluation. So it will be difficult for the court to make such an order. And the second limb, or the second issue, being a funeral and likelihood of the respondent meeting the potential witnesses is very ripe. So in that case, the same might jeopardize the investigation. So the request is hereby declined.
Most obliged.
So come back for mention to the 14 days that will take us to which date?
17th of June.
17th of June.